Welcome back to the Wealth Actually podcast. I'm Fraser Rice. With the Supreme Court's ruling in the Loper case, courts no longer have to defer to agency interpretations of ambiguous laws. This is a massive change in the way administrative law is practiced at the federal level. The Loper case touches almost every area regulated by the United States government, including small business and wealth management. Georgetown law professor William Buzzbee will help us understand the implications of the Loper case and what the world might look like going forward. Welcome aboard, Bill.
Thank you very much. Nice to see you.
Oh, it's been a long time. I'm sure my undistinguished presence in your property class way back in time didn't help, but it's important to have you on because we have a new Supreme Court case out that has really changed the dynamics around administrative law. You're the first person I thought of to talk about that because that's been your specialty. Tell us a little bit about what you deal with in administrative law and maybe a little background on how that works within the context of separation of powers in this country.
Sure. So most of what people think about as the government is carried out through departments and agencies, and the Securities and Exchange Commission, the Internal Revenue Service, the Environmental Protection Agency, various employment, labor, state work safety. These are all agencies and departments that make the law real. And there's a whole body of law called administrative law, which basically governs how agencies such as these can act and how courts review them. And a lot of this law has historically been about kind of how agencies can do their day-to-day work that structures much of our economy and that is foundational to how people feel protected or unprotected, and really how they structure their lives and businesses. So the case you referred to, a big decision by the Supreme Court this past term called Loper or Loper Bright, some people call it, changed some very long-standing basic understandings about who has what powers in our government. And it's going to shake out in many different, maybe unpredictable ways that are very important.
So take us through a little bit what the framework looked like before. For most people who are sort of reading about the case and saying, oh, it's an important case and how it's going to affect my business or that type of thing, it fell under sort of the Chevron doctrine. And maybe if you can go through and explain what that did and what that tried to solve for.
Sure. All of us have been so excited by the Chevron case for decades. But there was a case decided in the early 1980s called the Chevron case, which articulated a very basic set of rules about how courts should review the law interpretations of statutes. And at its most basic, it said that courts should, in most instances, show deference to expert agencies that have been handed power by Congress to regulate various risks or markets, or whatever the issue is. And so it was in the world of law about as close to biblical as you could have. That is, it had some very basic, crisp frameworks, and it was, of modern cases, in many years, the most cited case in federal court jurisprudence. And so it basically governed the law of the land since it was decided in early 80s. By the mid-1980s, it was rock solid, and then became the law of the country quite clearly ever since. And so that was the law, that's Chevron, and that was saying courts defer to what Congress decides agencies should do, and courts defer to what agencies do in law interpretation. This new case flips it, this Loper case. And I can talk about that, but fire away.
Right. No. And so you have something that's rock solid, and it's something that businesses have been relying on, and people who interact with the government have been relying on at the agency level. What was it about Loper Bright that created the need for the Supreme Court to do a 180 in many ways here?
Well, I'm not sure the need would be quite right, but I'll say this. There's been a push, largely a political push, coming probably more from the Republican Party, but by entities that often oppose regulation, that came to view Chevron as a problem. They came to view Chevron as giving excessive power to regulators and the administrative state. And then there was maybe a linked concern that judges weren't really doing their work, that judges were too readily just saying, okay, agency, what you're doing is good enough. And so this push started, people date it differently, but I would say roughly about 10 to 15 years ago, there was a growing push to trim agency power by getting rid of Chevron deference. And so as the Supreme Court became progressively more conservative, it became clearer and clearer that there were the votes to somehow redraw the lines between judicial power and agency power. At first, the court stopped citing Chevron. That started around 2016, 2017, or stopped relying on it in majority opinions, I should say. And then lower courts still had to apply it, and agencies thought it was still the governing law, but people saw that there was a shift coming, and the Loper Bright case ended up being the vehicle by which the Roberts Court got rid of Chevron deference and created a new regime.
The new regime, what is the effect of that? Or how, if you're a lawyer sort of advising a client as far as someone who's in front of an agency and they're not really happy with the way they've been treated for one reason or another, or they want a different outcome, what's the difference between what was in place with Chevron and what's in place now?
At its most simple, under Chevron, if an agency was given essentially a range of choices informed by their expert study of a sector, the Chevron case said that courts should kind of let close calls go to the agency. The idea was agencies know more than do courts. Agencies are supervised by presidents and hence are more politically accountable. And then in addition, subsequent cases kind of refining Chevron made clear. And if an agency goes through a kind of a political give and take process called notice and comment rulemaking, that an agency regulation interpreting the law is kind of at the maximum strength or power, that in that setting, courts should defer to reasonable agency choices. The flip is the following. The Loper Bright case says no more. It basically says instead, courts should exercise their independent judgment to determine the best meaning of a statute, with some caveats that I'll talk about in a second, but basically says, so courts really are no longer to give those close calls to the agency. What the Supreme Court has said, courts, you try to figure out the best meaning of the statute and you go with that. And that's just a dramatic shift. I mean, because before it was defer to reasonable agency choices interpreting the law. And the new case says, no, courts exercise independent judgment, determine the best meaning, and make sure that's what the agency has done.
And so that shift in power essentially, I guess, from the executive branch to the judicial branch, it's seismic in many ways, I think. And then add on to that, if you believe that the agencies are the experts of the domain of which they're regulating, versus having to get a court up to speed on some probably pretty complicated issues. I'm looking at the IRS or the tax code in particular, where, you've got people who spend their whole careers on that and end up twice as confused as when they started. I mean, that's a major shift. And as you look at it, and as you sort of think about the caveats you were talking about before, who do you think are the real winners and losers in that scenario, as from a business perspective or from any other perspective?
Well, I'll tell you the caveats and then talk about winners and losers, because I think that will make it clear. So in this opinion, the court had a problem, that statutes actually going back to the founding era have been creating laws that hand power to agencies, departments that kind of carry out the government's work. So these laws exist, right? And they tell agencies to do things. And so the court kind of had to say, what do we do with the fact that agencies have to study sectors and study problems and make choices? And so within the opinion, the court says, effectively, this isn't to deny that the court's not denying that agencies are given discretionary power. And so the court says agencies still have to study sectors and make fact-based decisions. And so the court doesn't get rid of the reality that agencies are there doing work. And so that's a very important caveat. The big difference there is the court is now kind of saying, show us that Congress expressly told the agency to do something. And then importantly, then the courts have to really agree exactly the nature of what that empowering of the agency said. So what does this mean for winners and losers? The big winner is judges. Okay,
Right.
so this is a big empowerment of judges, and so this is where it becomes a kind of a funny and complicated game about regulation. And I should say to you and your listeners. So I did public interest, environmental work, and regulatory work, but I did a lot of work also for corporations and corporate entities and not-for-profits doing work. People who were trying to comply with the law. And this is the kind of the puzzle. The regulatory process is a kind of structured, routine-based, interactive process where people who care about regulation interact with regulators, and it's always a back and forth. And so whether it's tax policy or environmental policy or regulation of people who trade in securities markets or financial advisors, any of these people, when agencies are interacting with those regulated, it's an interactive two-way process. And so under the Chevron doctrine, as fleshed out over the years, agencies basically were told, you better do a good job, you better interact with those you are dealing with, and you listen to them and explain your choices, and then you'll get deference, okay? But it meant that agencies were generally making sure they were informed and hearing what people's concerns were, which meant it was kind of stable. The odds of terrible mistakes are kind of small when agencies have to interact and explain themselves. The problem is what you said, which is courts don't know much. Yeah, it is courts or judges tend to be smart and well-educated, but they are generalists. So they won't know the nitty-gritty of pollution control. They won't know how energy market securities are traded. They won't know about financial advisors and secondary markets they work in. They don't know insurance. That is, you name a special sector, especially a financial sector, judges won't know much. And so there is this twist or this paradox that this decision is kind of anti-regulation, but it probably is going to give rise to a lot more unpredictable results that may unsettle markets, or at least make it hard for people to play in the regulatory settings to make sure regulation is good.
I mean, right off the bat, I could envision one court having an opinion on a regulation and then another having, with a different set of facts, having a different opinion on the same regulation. And then all of a sudden, you're right back to the Supreme Court trying to get some guidance on what was actually meant. I mean, that seems like a risk that we're looking at going forward.
Yes, there is very much that is the case. That is, a lot of statutes, when people are unhappy with regulation, they can go to different judges and they could get clashing opinions. And there's also, I should say, the world that's important from this past summer is not just this Loper Bright case. There's a kind of a sleeper of a case called Corner Post. And the reason why this matters also is the following. It's generally the law for many decades has been, if an agency finalizes an important regulation, there is a limited time, sometimes months, sometimes a few years, where those who are affected can challenge the regulation. And as I'm sure you know and your listeners know, there are many sectors where businesses are designed around regulations. Like once they understand what's required for a merger and acquisition, under regulations, they'll design the structure so they comply with the law. This corner post case really unexpectedly said an entity that's not in existence at the time that a regulation was finalized can challenge it far later, long after regulation is finished. And the reason this is a problem is it's very easy to incorporate a new entity, right? And so if one set of businesses may structure their business around a regulation, and whether they like it or they don't like it, they can work with it, and good lawyers will advise them. But this case basically has unsettled the law in a different way, saying most major regulations are potentially going to be challenged by newly created entities who feel aggrieved. And so that means you put those two cases together, judges are now deciding more based on what they think, and regulations are less stable because they can be changed long after they seem to have been finalized.
Can Congress do anything on this front as far as being more precise in the legislation that they put in? Can they put in language that says, judges, thou shalt give deference like Chevron in the past to the things that we're talking about going forward?
So structurally, yes. Okay. So several things. First, Congress could issue clear instructions to agencies saying that what they can and they can't do. So if there's some bad judicial opinion, Congress has the power to go back and pass a new law and fix it. And so that's possible. And Congress also has some power to structure generally how courts review what agencies do. So that's possible. But the reality is we're in a state of partisan gridlock in Congress, and it's very hard to pass laws. And so there's far less major legislating going on today than there used to be. And so while the power is there under the Constitution, I think very few people think there will be easy legislative correction, either of Loper Bright or maybe future cases if some regulation that's important or statute is undercut.
How does this trickle down to the state level? If you're going in front of New York, in a New York agency, I would think that, this is interesting law for the judges to apply on that front. Mm-hmm. Or is this something where the states can sidestep what is happening with this decision?
The answer is kind of two-part. Okay, so one is, Chevron is a case that has applied to federal courts applying the work under federal statutes of federal agencies, meaning arms of the United States government.
Right.
So it doesn't literally apply at the state level. Some states have jurisprudence, cases that are like Chevron. Some states have already rejected Chevron-like approaches. And so it doesn't literally apply. But there is one way in which it will apply. A lot of the work of governments, federal, state, and local, is carrying out structures and programs where federal law encourages states to play along, or state and local governments receive federal money and then are implementing federal programs. And so those are a lot of the body of regulatory law is thus being applied by state and local governments. And so what will happen? Well, state and local governments may themselves be subject to this instability as well.
One of the things that going into the Wayback Machine a little bit here is this concept of the major questions doctrine, where in a sense the judicial system could go and sort of deal with different issues in the administrative law world without sort of in tandem with Chevron, but maybe in a different way attacking what's in place. Is that another part of the jurisprudence that's surrounding the issues here?
Yes, that there are, since 2022, there have been several decisions where the Supreme Court has now articulated and embraced this thing called the major questions doctrine. And it is kind of you could look at it as working in conjunction with Loper Bright to also hand more power to the courts. Basically, this is a doctrine that says if the courts think that an agency is acting in a way with major consequences, especially disruptive consequences, then the courts can make sure the agency's power has been clearly conferred by Congress, meaning the statute empowering an agency has been clear. And so the major questions doctrine is an anti-regulatory valence. It skews against power. And that itself is another way in which courts might say, no, 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 agency. The words seem to say you have this power, but not clearly enough. And what you're doing is too disruptive, therefore, no. And so Loper Bright says, determine the best meaning. Major questions is saying, well, even if a kind of reasonable meaning might be okay, if it has major consequences, it has to be really clear. And so that in conjunction, you could look at Loper Bright as sort of taking the wind out of the sails of the major questions doctrine, but I think most people see them as working in tandem, and they both end up being judge empowering doctrines and weaken the power of agencies to do new things. So one big effect, and this may matter less in the world of regulation, but agencies deal with emergencies, right? And so when there's a market meltdown, or there might be, say, a sector that suddenly develops a problem, and agencies want to step in to address a new emergent risk, that Loper Bright says, well, you better show us that you have the power under the best meaning of the statute. And then major question says, okay, are you being disruptive? Well, anything new, any new action disrupts a bit. And so the major questions doctrine also makes it hard for agencies to respond to emergencies. So there were several decisions taking away agencies' powers to address the COVID emergency a few years ago,
right?
And where the court said it's just not clear enough. And so kind of agencies' emergency powers are now weaker than they used to be.
So if I'm an agency or the head of an agency, or part of the executive branch, and I'm thinking in terms of the IRS here, where people are sometimes go to the IRS for private letter rulings or things that don't have the teeth of an administrative rule or maybe even statute, that type of scenario. Could you envision a scenario where agencies start to really play in that sandbox, understanding that they're trying to provide guidance and some stability in a world that's unstable, but at the same time understanding that each one of those particular semi-rulemaking situations or determinations are part of the framework of the jurisprudence going forward?
Yeah, that's a really good point. So you must have been well educated when you were in law school. So that's this. People have found this in other settings. If the courts or other circumstances create costly hurdles for agencies to do things that might be needed, sometimes, frankly, people are clamoring for regulatory clarity. So then agencies will look at less conflict-laden ways to act. And so what they may do is go to these more granular, smaller scale settings where they might, over a sequence of actions, sort of roll out how they approach things, or piece by piece address circumstances. And so in that way, avoid some big declaration that might be viewed as disruptive or unexpected or a big power grab, and instead act in a little more responsive, small scale way. So the good thing about that is, big mistakes may not be made, right? And so that is itself a possible benefit. The problem, though, is that can also mean that people trying to predict the law have less ability to shape the law with the agency as they had been doing. And the other is also that the agency is less likely to declare in a big way, here are the national rules, everyone just live with this. And that's a benefit in many sectors, having a kind of a clear national rule. And so you So agencies will find ways because people seek guidance and agencies try to fulfill their obligations, but it may be a little less national, a little less clear, and a little more revealed over time.
So if you pulled out your crystal ball, we've got really a seismic change in administrative law and the way things are going to be done going forward. What do the next 5 years look like? And this is a brutal question to ask somebody to predict the future, especially in light of a 50-50 election and sort of complete uncertainty into how things are going to be deliberated going forward. But with this new framework, what do you see going forward, and either impacts on business or any other wreckage that you could see around the corner?
A lot of wreckage. So I guess I'll answer in several ways. So one is, so agencies are going to do their work differently, right? And this is part of the reality. So agencies answer to presidents and answer to Congress, and there are whole business sectors dependent on regulators doing good work. And basically, there's a common, I think, program of no one really wants agencies to melt down or have whole sectors melt down, right? In other words, it's bad for politics, bad for markets, bad for investors. So one thing is people are going to try to find a way to make sure that agencies still protect everyone, protect markets, protect workplaces, protect the environment, protect civil rights, all of that. They're going to find it harder to do so. Okay, so the effort is going to be harder. So one thing agencies are already doing is doing much more detailed digging into facts, and when they're acting on important regulatory matters, really being very clear, saying things like, this factory in Ohio is doing the following now. And that's why we're saying this is doable. That is, they're not like we're looking at words. They're trying to say what we're doing makes very good sense. And so agencies will try to get consensus, address risks, get people to come aboard, and establish that what they're doing is good. So that's one important thing. Here's the second thing, which is unfortunate, which is I don't care what a regulation is, that is, you may have any regulation may have a huge number of entities that love it. Like really, they love it. I mean, when I was practicing, I would give people advice about various regulatory regimes, and they just wanted to know what the law was. Like one business person I heard speak, not a client, but at a regulatory venue said, I don't care what the rules are as long as I know what the rules are. And if I know the rules, I'll structure a business and I'll make money. And so the big problem here is you may have lots of entities who are happy or at least adjusted to regulation, but someone won't like it. Okay. And basically this whole regime is just these new lines of cases basically are a roadmap for people to destabilize regulation. So what may happen is you might have 99 entities that are happy with a regulation or a regulatory regime, but one entity may want to come in and challenge it and will make a case why they hate the regulation. The big question is, will a reviewing court have the wisdom to say, oh, wait a second, am I assuming this one complainer is representing a broad concern, or is it just someone who's maybe in some cases a bad actor, right? There are sectors where bad actors are the problem, and the best actors are exemplary. And that's actually a common setting in regulation. There are, best actors in every sector, and they often are happy with regulation. They figure out what needs to be done, and then there'll be others who want to skirt the law. And so that's a problem, is that people may face destabilizing, not from themselves, but others trying to get out.
I was going to say, maybe, sort of, is the judicial system equipped to deal with this? Is there going to be an avalanche of litigation that suddenly clogs the courts, where you've got different courts dealing with different things, and then the pie chart of matters suddenly skews towards the regulatory environment?
Yes. So for people who are, working in settings where there's support for challenging regulation, it's going to be a good next few years. And so there will be more challenges. Like there was a recent study, I think it was a reporter I both spoke to, but then did some subsequent research. And so I haven't checked the numbers, but I think an article in Bloomberg said something like there have been 38 new cases applying these new, more searching regimes, the Loper Bright case plus these others. And I think 25 out of 38 found the agency power to be that the agency went too far, basically rejecting the agency's action. And a lot of these were from new judicial appointees from President Trump. And so what you're going to have is people are seeking out sympathetic judges. A lot more regulations may be struck down. And we'll see. There is a slight chance, I'd say a slight chance, that some important sectors may try to get the Supreme Court to clarify and pull back a little bit from judicial overreach. Because as I said, this case did not say agencies should not have discretion. And it talked about courts have to respect what Congress has done. These new decisions are not showing that kind of respect. They're taking this case and running with it and maybe running far past it. And so there's a slight chance the court might curtail lower court overreach. The other possibility is the justices will take this and keep going. That is, like, we don't really know whether they view themselves as, in the football metaphor, if they've gotten the ball 70 yards down the field and that's good enough, or they view themselves as just getting going and they have to keep, trying to get new first downs and dismantling the administrative state. We don't know.
Terrific stuff, Bill. Thanks so much for being on. We've got a lot to watch. It's probably the one set of people who will definitely benefit are probably expert witnesses. they will be fully employed along with the lawyers too. So
I think that's true. Well, thank you for this, and thank you for your good work and helping people get out there and understand how the law works in this area, and especially how it affects markets and your viewing and listening audience. So
appreciate it. Thank you.
Okay, take care. Stay well.